No matter how much effort is put into planning an estate, the plan won't work smoothly if the wrong executor is chosen, or if you have a living trust, the wrong trustee. Hi, I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. And today I'm going to discuss 5 common red flags to be mindful of when choosing an executor or trustee. Your executor, referred to as a personal representative in some states, may have a wide range of responsibilities, such as arranging probate, identifying and taking custody of assets, making investment decisions, filing tax returns, handling creditors' claims, paying the estate's expenses, and distributing assets according to your will. The trustee of a living trust, also called a revocable living trust, will have similar responsibilities. Here are some common mistakes people make when choosing an executor or trustee. Red flag number 1, just automatically choosing a family member. You want to select someone you trust, and a family member may be appropriate. Too often, though, family members lack the requisite skills and experience with financial matters, though they can retain professional advisors. Also, choosing a family member can create tension if other relatives believe your choice is biased. But in the end, it's your plan, and you get to choose whomever you like. Red flag number 2, choosing someone far away. While it isn't necessarily wrong to choose a person out of state to serve as your executor, it does have some drawbacks. Selecting a person who lives and works at a distance from the location of your assets and beneficiaries can make the process more difficult, time-consuming, and expensive. There are a lot of tasks the executor can do themselves instead of having an attorney perform them. When someone resides out of state, they are much more likely to have the attorney take care of tasks that require being present locally, like clearing out a safe deposit box or even clearing out a house. This adds expense to the process. The executor may seek to recoup any out-of-pocket expenses from the estate. They would be paid before any distributions are made. So, while it's not wrong to choose someone that lives out of state to serve as your trustee or executor, if there is someone locally that you can choose, consider doing that. Red flag number 3. Not making sure the person is willing to serve. The person you name to serve as your executor or trustee isn't obligated to take the job, so be sure to discuss your plans with them first. Even if they say yes now, you would want to check with them every few years to ensure they are still willing to serve. This is why it's a good idea to review your estate plan at least every 3 years or so. If the person you name changes their mind, you will hopefully have time to change your will or trust. Now, this happened recently with one of my neighbors. She was named to serve as an executor in someone's will, and when it came down to it, she didn't want to do it. But at that point, it was too late for the person to change their will, and so other measures had to be taken in order to find an executor. Red flag number 4. Failing to designate a backup. You should name 1 or 2 alternatives in case your first choice declines to serve, or resigns, becomes incapacitated, or dies before your estate is settled. If you are low on people to appoint to serve and only name 1 person, you absolutely need to review your estate plan at least every 3 years to ensure that person still is willing to serve. And finally, red flag number 5, and this one's a bombshell. I know it might be tempting to want to appoint co-executors. This sometimes comes up with clients who have multiple children. They don't want to leave anyone out. Co-executors or co-trustees can create other challenges, though. When it comes to naming someone to serve as the executor, this is not the time to worry about leaving someone out. Your family could end up in a situation of the co-executors not getting along on a personal level, but also making contradictory decisions. This creates strife and dissension in families and can ruin relationships. Now, you're also likely going to be hard-pressed to find an attorney that would be willing to represent co-executors. And in the worst case, each executor hires their own attorney to assist them in performing their duties. This would significantly impact the assets of the estate, as attorney's fees come out of the estate assets and will come out before any distributions are made. I'm Antoinette Bone, estate planning, probate, guardianship, and elder law attorney in the Dallas-Fort Worth Metroplex. If you found this content useful and would like to see more like it, please subscribe to my page, like this video, and don't forget to tell your family and friends. Thanks for watching, and I will see you next time.